Live from SABC studios in Auckland Park, Johannesburg. Welcome to this midweek edition of the Watchdog. My name is Vuyo Mvoko, and on the show this evening,
Chris Hani had only but one life to give for his country. He has paid the ultimate price and given us his life. We can't betray his memory.
The governing party and its allies pile more pressure on their comrades in government to keep Chris Hani's killer Janus Walusz behind bars. But is there a legal basis for their demand?
The report will be communicated to members of parliament through the next publication of the announcements, tablings and committee reports tonight.
As South Africa awaits the release of the independent panel report on Phala Phala, we build up to its expected midnight release.
Isn't it time for women to be at the helm?
We'll also look at the possibilities for those who may or may not benefit, depending, of course, on what the report says and how Parliament and the ANC may deal with it. The Watchdog starts now. The Department of Correctional Services is still mum on the release of Chris Hani's murderer, Polish immigrant Janus Walusz. He's expected to be released tomorrow. Today, the SACP, the ANC and COSATU marched on the department, ostensibly to put pressure on the authorities to keep him behind bars. Yesterday, the Hani family and the SACP filed papers with the Constitutional Court for a rescission application. This on the same day Walus was admitted to a prison hospital after being stabbed by a fellow inmate. Kenny Mapanga witnessed today's protest actions.
Details surrounding the release of Chris Hani's killer, Janus Walusz, remain unclear.
It's an appropriate authority who has to make that decision. And with this particular one is the minister. As you'll appreciate that Mr. Walus is a lifer. It's a minister who then gets to make that particular decision. Yes, there is a court order, then the minister will do what he needs to follow legally so at the right time, the minister will make his intentions known.
Malo spoke to the media following a protest by the tripartite alliance to the prison where Walusz is serving a life sentence. The said protest made a political statement against the release of Walusz, stating that he had not been transparent on the brutal assassination of Hani. Therefore, further action would follow.
Judges are not God. Their word is not final. But the action that we have taken as the Communist Party on behalf of the Alliance, as well as on behalf of the Hani family, we're acting together in unison in this regard, was to look at the legal avenues available to us. We have yesterday served legal papers to the Constitutional Court to call for a rescission order on their decision to release Janus Walusz.
In addition to the rescission application, the Minister of Home Affairs granted Walusz an exemption in order for him to serve his parole in South Africa. However, the country is yet to hear from the Ministry of Justice. Numerous attempts to reach Walusz's lawyers were unsuccessful. Kenny Mapanga, SABC News, Pretoria.
Sole Mapaila is the General Secretary of the South African Communist Party, and he joins us on the line. Good evening, sir. Thanks very much for your time. Am I correct in saying your central argument is that Janus Walusz never got to apologize to the Hani family? Okay, we seem to have just lost Sole Mapaila. Hopefully, we're going to re-establish that line. But let's bring into the picture now Mpumelelo Zgalala, who is a legal analyst, as well as Dr. Mkhuseli Vimba, a political and legal analyst, who will also be joining us shortly. But let's see if we do have Mr. Sole Mapaila now. We do not have. Okay, we are in a short while going to hopefully get him back on the line together, of course, with those analysts who are going to help us, enlighten us on whether, in fact, there is a legal basis or a case at the very least that can be made for Janus Walusz to stay behind bars as the South African Communist Party would want him to. And if they were to succeed, what does the law say? What does the law say? Can anyone really stop what the Constitutional Court said needed to be done? My question to you, Mr. Phala, earlier was whether in essence, you're arguing that the Hani family never got the apology they ought to have gotten, but also that Janus Walusz never really revealed the truth about what actually happened. Is that what you are relying on in the main in the application that you filed?
Thank you for your story about the connection difficulties. The main contention is the fact that the Constitutional Court never heard or responded to our application. As you would have heard in the judgment, we are only referred only insofar as being party to the applications, but the content of our submissions have never been considered. We feel this is violating our rights. We ought to be heard. We're not just a by the way applicant joining the department. We were supposed to be heard and to be responded sufficiently, and that was not done. On that basis, we have raised legal issues regarding our submission and heads of arguments that were not listened to by the Constitutional Court or even responded to or judged against. So we were judged in generality, and we think that that's quite unfair to us. So that's the first main legal ground. Mm-hmm. Of course, the second one is that there are errors in some of the conclusions. For instance, regarding the victim-offender dialogue, the process that from our side, the Hani family never conducted such. The Janus Walusz and his lawyers mischievously tried to abuse that particular process by seeking to send a letter at that time when they wanted the address of Hani to send a letter, which we could not, of course, just hand over her address to people that have killed their husband after they conspired to get their address in the past. So we simply indicated that at that time, she was not around. She was on holiday in Cuba, invited by the Communist Party that side also to honor her, to honor Comrade Chris Hani. And before we knew it, they used that as a basis to say they've reached out to her. Completely mischievous and unacceptable. But somehow the correctional services system accepted that. But there's never been a process of engagement. We have not even reached a point where the Hani family, through System 4, would have engaged with him to say, now that we have told the truth, we accept it or not accept it, we forgive you or not forgive you. But the bottom line, he has never told the truth, he has remained unrepentant and unremorseful. That's the basis all these years we've opposed him to be released on parole.
What happens if the court says it has satisfied itself that indeed the Correctional Services Department did what they could do in terms of the law and regulations, even on the matter of an attempt that Janus Walusz and his lawyers made to actually reach out to Mrs. Hani? All of that was in order and was above board. Would you leave it at that, or especially given the fact that we are now, you're petitioning the Constitutional Court, which is...
Look, we do not want to reach a situation where it seems that we are questioning the outcomes of the court. We are simply saying, let the court follow due processes. In this case, our submissions were not yet. If they've read our submission, they could have questioned us. They could have questioned our advocates about why we're denying that this has happened when the correctional services said this has happened. I was at the first hearing, the parole hearing, when, for instance, Ms. Hani indicated to them that if you want to talk to me, please talk through my lawyers. They never did that. And some few years later, despite what she had said to them, she then indicated at the memorial site in Thomas Nkobe Cemetery, she then indicated that even up to now, they have not apologized. That's when that week, they then tried to call us to say they're tracing her because they want to send this letter. And we indicated she's not in the country and she won't be able to receive the letter. Only to find out that they were using that mischievously for this process that they've done. So they will make a ruling, which of course we are accepting, because there's nothing we can do against it except to use the legal avenue remaining in our hands, like the rescission order that we have tried to serve on them yesterday, which has now been processed. We have all the reference details. We have also served Janus Walusz lawyers, who were quite difficult and completely inhuman, because they kept our lawyers outside for almost 45 minutes. I don't think that's how they should engage with their colleagues in the legal fraternity. And over the years, we've been going to court with several of their representatives. They could have said, the letter that we wanted to serve to you, here it is, and they could have given it to our lawyers. They never did that. So there's never been a process. The law itself, the parole conditions, the parole law itself has been violated, and the Constitutional Court condoned it. So if we say it is wrong, it's as if we are wrong ourselves. But the point is that they are making a conclusion on a matter that did not happen, and that's incorrect.
I mean, I thought that was very important, because, I mean, you will have seen, heard from conversations that South Africans have been having over this matter, that people deduce that you're just refusing to let go of this because you want this man to rot in jail, and there are no process issues involved here.
Yes, of course, that's why they pitted us against the people unnecessarily on this matter. The bottom line is that in terms of the Parole Act, if they read it, they will find the details there that indicate that the offender, because parole, by the way, is a continuation of a sentence. It's a privilege. It's not even a right. The Act says it clearly. So they'll find that there's a process to engage with the family or the victims in this regard. So that has never happened. The forgiveness aspect, it can take place when someone has spoken the truth, and the family can then decide on what basis to move on. By the way, after all of this has been said and done, the engagement between the offender and the victims, whether the family says we forgive you or not, it's immaterial. The point is that they will have listened and heard the truth. And that's what, for instance, has happened with the cop, Prime Evil, who killed so many of our comrades. He was ultimately released on parole, precisely because some of the families that he met, he was sincere, he felt remorseful, he asked for forgiveness, he collaborated with the NPA and the investigators, he went to show them where they buried some of our comrades, which they've hidden them all over these years. So those families, some of them forgave him, others did not. So ultimately, he was able to yet engage in the victim-offender dialogue genuinely. Although we are still worried about the fact that a man who killed so many of our comrades is free, he was released, and the families were satisfied that a process has taken place despite that their loved ones cannot come back. In this case, we're not getting the truth. And Janus Walusz, as co-conspirator, Clive W. Lewis, even indicated that he will commit this thing again if he were to be given a chance. And he recorded that and said this must be released on his death, precisely because these guys had never been remorseful, both of them.
So Phala, let me thank you for clarifying that for us, and of course listening in to that conversation. Mpumelelo Zikalala, a legal analyst, as well as Dr. Mkhuseli Vimba, who's also a political and legal analyst. Good evening to both of you. Thanks very much for your time. You heard what Mr. Phala had to say there. Mpumelelo, your thoughts? Okay, we seem to be having problems with these lines today. We just felt we needed to that clarity from the South African Communist Party as to what it is exactly that is the issue for them. The court was not fair, as you heard Mr. Phala saying. So they are questioning issues of process. And Mpumelelo, I hope you are with us now. Just your thoughts, having listened to what Phala had to say there?
I quite agree with him, and it comes back to this point of saying that the court are not in the business of granting parole. It's the job and the absolute role of the minister. The Correctional Services Act states that. Now you can't go, or as the court, step into the shoes of the minister and be able to take the decision on behalf of the minister, because you're not going to be privy to the various facts in which Mr. Phala has carefully stated out. So at the end of the day, you are going to take a decision which is incorrect because you don't have all the ingredients and important elements that must be considered at the end of the day. But linked to that is this element of justice of saying that when someone is being sent into prison, there's a famous case of S versus Zin that looks at all the important elements, three mostly, which is the victim, the perpetrator, and also what is in the interest of the community. For sure, or surely it must be reasonable enough that when you are going to take a decision to release someone on parole, at least some of those elements must be considered or ought to be considered at the end of the day to ensure that people can be able to trust in the legal system, but most importantly, in the principle of justice.
Mm-hmm. And you hold that position, Mr. Zagala, even where the court had said, well, the House and who will make the final determination is going to rest with correctional services. They are not going to prescribe. That was the judge did say something to that effect.
But they have already prescribed. When the judge says that you must release this particular inmate within 10 days, they've already given their particular order. Most importantly would be, how did you arrive at the amount of 10 days? What informed it? What do you think 10 days is going to achieve? What can be achieved within this particular amount of time? The type of problems which correctional services is faced with today, of where the Mr. Janus Walusz is going to be housed, are the exact type of issues that could have been considered by the minister. If the order could have said, we are not going to release you yet because that does not fall within our powers. However, what we are going to do is refer your matter back to the minister, and the minister will be able to reconsider it after we've highlighted all our concerns as the court. On that basis, then the minister can come back and say, we have the budget, we don't have the budget, we are going to be housed, we have an issue with regards to citizenship, and all of those factors ought to have been considered. Now, if the court makes or takes the bold decision of saying that we are going to step into the shoes of the minister and grant the parole, it does not fall within the amendment. It's a clear breach of separation of powers. It shouldn't be done and ought to have not been done by the court. That's why you have the type of issues and problems that you have today.
For you, Dr. Vimba?
Hello, can you hear me?
Yes, we can hear you now.
Yes.
Just your thoughts on what Phala raised as being the issues for them and why they decided to petition the Constitutional Court.
Thank you for your and to the viewers. I think they have a point if they say that the process has not been followed. As you will recall that the parole system requires that the victim must meet with the family and discuss the nitty-gritties and see if the family accepts his or her apology. So if the process has not been followed and they feel that they have been robbed in the process, then they have every right then to petition the Constitutional Court to review its decision.
Well, it says that there are things that simply did not happen. Dr. Vimba says, for example, the claim, what Janus Walusz and his lawyers tried to do, which was to ask for an address where they can send a letter to. That simply didn't happen because they were never given the address, and Mrs. Hani, of course, I mean, needless to say, never got the letter. So they feel the court erred on that one because that was one of the requirements. I mean, that would have been one of the prerequisites for whatever determination, irrespective, he says, of what Mrs. Hani and the family would have said in any event.
The in-laws of Voya, especially when you are served, if there is a feeling that you are avoiding the process, a decision or the court can come to a conclusion to say that this person does not want to involve himself in the process, and therefore the court may make a decision. But in this instance, as you have heard from Mr. Mapaile, that at some point Mrs. Hani was abroad and she asked that they took through her lawyers. So that did not happen. That may be a serious problem, because if she has indicated that she's out of the country and there are people that they can talk to in her lawyers and they did not follow that, then that becomes a problem.
In fact, I mean, it's interesting. I mean, you raised that, which of course Mr. Mapaile countered, because that not only does it say that Ms. Hani was not around, was in Cuba where she and her husband were being honored, but also took some time off. He then also says that they could not give Janus Walusz the address because they're the same people who actually declared in even a recorded interview that given a chance they would do it again. So they too had their fears. But what if this man wants to go for Dimpo Hani this time around, having done so to her husband?
Yeah, that is a valid, that can be a valid reason in terms of them fearing for their lives. But as I understand it, Voya, Mr. Mapaile is very clear to say that they don't challenge the court in as far as following the law.
Yes. In
terms of releasing Janus Walusz, but they are challenging the process that it has been unprocedural. And the act has been sort of violated in terms of the court not heeding to their call for them to have a say in the process, especially the victim, because it's another question whether the victim or Mr. Hani or the Hani family accepts Walusz's apology or not. But the issue in question is that that process must be undertaken before the court comes to a decision to say that they release Janus Walusz. So hence I'm saying that at the end of the day, they have a valid reasons to petition the Constitutional Court if the process has not been followed, to review its decision and see if maybe the decision of the court can be reversed on those bases.
Mr. Zikalala, what, in your view, would their case hinge on?
Basically on, firstly, which is the separation of the principle of separation of powers. Secondly, the question of saying, did you have the proper record that would allow you to come or to arrive to a decision of releasing someone on parole, firstly? And if you're going to release on someone on parole, have a proper record that would even allow you to put time limits, or what, most importantly, inform those time limits in terms of saying they must be released within 10 days. Now, what we have heard over the past few days, it shows that it is not quite an easy process when it comes to all the things that are applicable. So it's not a process of waking up in the morning and saying that we are going to release someone on parole. There are various investigations that must be done, various confirmation that must still be obtained at the end of the day. So it's not a process of waking up in the morning and saying, we are going to release on parole and it ends there, which is a much more compelling case of saying that is why the sole discretion of someone to be released on parole and the conditions that must be applied to that person to be released on parole rest solely with the minister and not with the courts. Because whatever could have been privy with the courts or the court that will have access to is a list of affidavits detailing of why parole should be granted. All the other interviews that could have been done with the Hani family, for example, are not listed anyway. All the other interviews that could have been done even with the SACP are not listed anyway, which puts the court in a position in which they can't make an informed decision due to the record not being sufficient enough for them to apply their minds. So the only thing in which they could have ordered was to say, go back, minister, and go and reconsider this application. Hence, a variation application to say, we want to vary your order that you have issued. We don't have a problem with stating your case as to how parole should be applied, but we have a problem with you taking the powers of the minister and using it as your own when you don't have the proper and true record of how this particular assessment of parole and even the conditions ought to be issued in this case.
Now, and then what then happens, Mr. Sgala, to the, he was expected to be released tomorrow. And the SACP and the family filed yesterday. Does that put that decision in abeyance? In other words, does now their application supersede what was supposed to happen, which was to be released?
The assumption would be that this particular matter has been brought on an agent basis. Now, agency, the court would look at various things like saying, is there a right that needs to be protected? Is there going to be irreparable harm that is going to be suffered? What are the balance of probabilities in terms of who may win or who may lose in this particular matter? Before we move on to the realm of what ought should happen at a later stage with the merits of the case, meaning the decision or maybe the variation application which will be brought in by the SACP. But from where I'm sitting, I think there's a much stronger case of saying that the court may come to the conclusion and say no one is going to die if you're not released today. Yes, you may have an order which is in your favor. However, the applicants in this matter also deserve a right to be heard. And let's allow them, and we're going to place them on a special role or allow or shorten the time that it would have taken for them to come to this one of court. So you want to hear the basis of or the merits of the application. And only after all these issues have been done in justice, you can then come in. Nonetheless, the rules of the court when it comes to variation of orders and similar things was inserted with the sole intention of preventing the harm and preventing certain orders which one may think that are not just to be implemented, because once the person is out in the provided order of various elements, then it may render the matter moot at the end of the day. So I think the chances are quite high, depending on, of course, whether this matter has been enrolled on an agent basis and there's been sufficient grounds for agency, and also on the second part of the second leg of the matter, the merits of the matter of why should the court give back the powers of deciding the conditions and even whether parole should be granted back to the minister.
One wonders, Dr. Vimba, what both the opinions that you've just given us then do to the integrity of the judiciary. Remember, Mr. Hani made some strong remarks on the day that this decision was communicated, and there were also conspiracy theories from other people, and not just her. One wonders now, if indeed there are the loopholes that you have identified, what that's going to do.
Thanks, Avio. I think it will have serious repercussions on the judiciary in terms of how people see the decisions of the court. But I just want to say that it's a process that is allowed, that they petition the Constitutional Court. But at the same time, I think the way it has been done, it is also going to cause more damage in the sense that at the present moment, there are a lot of things. People may see it as rubbishing the judiciary to say that it should have not come to, because what Mr. Mapaile is saying is very clear to say they are challenging the process and the procedure that has been followed and information that may have not been considered by the court. But in the public eye, one may probably think that people see it as ANC or the tripartite questioning the decision of the court, because what the family said on the day of the decision was more of saying that this is a miscarriage of justice and so forth. And if then that is the notion and the thinking of many people out there, then people will tend not to respect the judiciary and tend to question its decision. We know for a fact that in many instances, many people have questioned the decisions of the Constitutional Court and other courts, of course.
Okay, that line again, but we got the gist of it. Special thanks to both my guests, Mpumelelo Zikalala and Dr. Mkhuseli Vimba. And that really was the point of bringing the story back today on the back of what the SACP and the Hani family filed yesterday. I mean, the protests that were held today and the reasons they are giving behind the decisions that they have taken. That no, it is not about denying Janus Walusz his rights in terms of the constitution, in terms of the law, but they are raising issues that they believe the court overlooked. We'll see how this pans out. After the break, President Cyril Ramaphosa has a case to answer. That's the breaking story we're going to be dealing with in a moment. Don't go away. To that breaking story now, President Cyril Ramaphosa has a case to answer on the Phala Phala saga. But before we get to what the report actually says, let's give you a bit of background. Earlier today, the judge who was, of course, leading the panel did hand over that report, and we're expecting it to be made public at midnight or thereabout from the information we were given earlier. But reports are coming in, and our journalists are still looking at this, are that the report is now out. We're going to give you some highlights of that report, but let's take you back to the handing over of that report this morning and what some of the political players had to say about what they think needs to happen next and who should play what role. Let's give you that background.
The Section 89 panel that probed the Phala Phala farm theft has handed over its report to the Speaker of the National Assembly, Nosiviwe Mapisa-Nqakula. Now the top officials of the ANC will be examining the report that could have an impact on the man who is leading the ANC's presidential race.
Come Wednesday, we should have a special meeting of officials, what you normally call the top six. At the moment we are 4. We should have a meeting and look at what the report says. We don't want any of our officials to start commenting until we have that meeting. If there's a matter of that magnitude, any leader will be bothered. But I think it's important for leaders to converse, have a discussion, and not rush to make conclusions. That's why we will be meeting on Wednesday.
But former President Thabo Mbeki has raised concerns regarding the implications the Phala Phala farm robbery could have for the governing party, which is less than 20 days away from holding its elective conference.
What happens if they say he's got a case to answer? What do we do? Bill? Because the population out there, its own conclusion will be, there's something wrong there. Wrong, maybe wrongly, because indeed somebody is innocent until proven guilty. The fact that a panel like that says that, it does not mean it's correct. But I'm saying you put out a notion like that, coming from this team of senior lawyers, all of them are lawyers, and they say we've looked at what we have, what we can, and it seems to us there's a case to answer. The leadership of the ANC cannot avoid meeting to discuss the question in the light of that. What do we do? Do we say to the president he must step aside? Or do we say no? Let it continue through the courts, through the parliamentary process. What's the impact of that on the ANC, in the public mind? I'm saying, comrades, one of the matters that people are saying perhaps a defining moment, a defining event, is because they are asking this question: what kind of leadership is going to come out of that?
The president is also sticking to his guns, remaining mum as investigative processes unfold.
I think I've put my case forward, and of course, let us leave it to that panel to come up with the outcome, and we cannot prejudge it. I can't, you can't, and we leave it in the hands of the panel. So they are best placed to deal with this matter. So any form of speculation really is misplaced. Let's leave it to the panel to report, and anything else that flows from that we handle then. And we've proven capable of being able to handle issues as they happen, and so let's leave all that to that process.
As part of his 138-page submission to the Section 89 panel, Ramaphosa said he did not manage the day-to-day operations of his farm, and certain facts set out were not within his personal knowledge. Natasha Piri, SABC News, Johannesburg.
Now, I'm reading you a part of the report, point 254, which says, we conclude, and this, of course, is Judge Sandile Ngcobo and his panel. They conclude, therefore, that the president has a case to answer on the proposed charge 2. They continue. These charges arise from the same incident, namely housebreaking and theft of foreign currency from the private residence of the presidents. The enduring questions are the following. 255.1, the source of the money stolen. 255.2, why was the housebreaking and theft not reported in terms of Section 34.1 of PRECA or to any other police officer for investigation? Point 255.3, why did the South African police request the Namibian police to handle the matter, quote unquote, with discretion? And then they go on to say, on this source of foreign currency, we only have the statement by the president, which is based on what he told or what he was told by Mr. Ndlovu, who did not confirm this information. It is true the president's version is supported by acknowledgement of receipt. Admittedly, on its face, the acknowledgement of receipt states that Mr. Sylvester Ndlovu received a sum of US $580,000 US from a Mr. Hazim, a payment for 20 buffaloes. We're still going, our journalists are still going through this, but this is the relevant part I have just received. I haven't gone through the report myself, and I do have on the line Kanye Magubane, who is a political analyst. Kanye, just from the little I've been able to tell you, your thoughts?
Well, I mean, I've just been furiously writing notes here as you've been speaking, and there's quite a number of issues that can be raised here. First of all, the release of the findings by the panel headed there by Judge Sandile Ngcobo is really quite telling of Ramaphosa's need to almost get all his ducks in a row before the start of the conference. But let's get into the actual findings themselves. The panel there saying that he definitely has a case to answer for, and as you've just read, they've stipulated the specific questions that they still need answers for. and notably it's the one on the involvement of the Namibian government. So the question we have to ask ourselves is this the kind of scandal that somebody running for the presidency of the ANC, the biggest political party, who for all intents and purposes will come back for another term of being in power? Do we really want the number one guy that we are putting forward to be embroiled in such scandal? And then this brings in what former President Thabo Mbeki just said. He asked a very important question. Is the ANC thinking about what's happening in the public mind? That's something very important that he raised, and that speaks to perceptions. Is the ANC thinking about how the future voters are looking at them right now, as issues of Janus Walusz have come out, and it has raised a lot of raw wounds amongst people, as we've seen in the many marches that have taken place. And right now we're having the ANC's number one president being embroiled in the Phala Phala scandal that just refuses to go away, because there's just too many answers that are still left open that people need answers to. There's too many questions that people need answers to that are not yet answered.
Well, from what Paul Mashatile, the acting Secretary General, the man running the ANC presently, told our political editor the other day, the ANC top 4, as they are now, they are not. It's not the top 6 anymore, because 2 of them are not part of the arrangement. Currently, one suspended, the other one passed away. That they were going, as soon as they got the report, they were going to meet today so that they know exactly, they decide what to say. They haven't done so. And part of that was, well, to my understanding from listening to what Paul Mashatile had to say, it was so that they speak in one voice and they go out there and say something that will make sense, but which will also presumably give direction to the party faithful, and I guess by extension the country. But I'm going to ask you to hold your thoughts right there. I see also that you're experiencing some load shedding there, but I want to bring into this conversation Pele Kwamfuyo, who serves in the ANC Women's League, where she is the Young Women's Coordinator. The story has moved a little bit. Pelegwa, I mean, just your thoughts or your reaction to the news we've just heard. Okay, we seem to have lost, I don't know what's going on with his lines. We seem to have lost Pelegwa as well. Kanye, I want you to listen to something that caught my attention overnight, and that was a remark, a video that, it's a very short video of Dr. Nkosazana Dlamini Zuma speaking, obviously, to the party faithful. Okay, it doesn't look like we can play that either, but where she was telling her supporters that her campaign is actually alive. It's she's continuing. She's in the running. It's not over yet. And I would bet my bottom Kruger rand, if I had one, that she would be basing that. She would have based that on the expectation of what may come out of this report as well. I don't know what your thoughts are.
Well, I think, first of all, Vuyo, kudos to her for fighting, because, part and parcel of the discussion today was to look at the fact that there is only 2 women candidates that are up in the top 6 positions that have been put forward, at least in the nominations that have been, taken out by the ANC. And Nkosazana Dlamini Zuma is saying that it's not over until it's over, because she knows that she still has a fighting chance to be, in the president's seat of the ANC. And this brings back to me the reason why I've always been critical of institutes like women's leagues within the ANC, because I believe that women in the ANC don't have any real power. They don't have an autonomy. They don't have a say that has the possibility of being different from the mother body, the ANC. For many years during times of elections, they are told which candidates to support. And I think that it's time the Women's League takes a decisive position to support women candidates, not because they're just women, but because the presence of women in a top 6, is very important, because the ANC is made up, believe it or not, mostly of women, as members of the ANC, if one has to look at the breakdown of membership. And so I think the current top 6 is disappointing. I think it's also expected. And Phoebe Potgieter, who's been put up as part of the deputy secretary names, I think she's most likely to take it, because she's been an administrator at Luthuli House for quite a long time. However, I would have loved to see more diversity, and I think that the ANC can still do better when it comes to gender diversity in their candidates.
What can you, with someone, who was going to talk to us about this very same issue you are raising, but before she does that, I'm going to ask her to react, Uphelekwa Mfuyo, to the news that Pelekwa, the president has a case to answer, and that around the enduring questions, according to the panel, the source of the money that was stolen, why the housebreaking and theft was not reported, and why did the South African police request the Namibian police to handle the matter, quote unquote, with discretion. Your thoughts about this news we've just received?
Thank you, Vuyo, and not trying to preempt on the report that has been before Parliament. I would allow Parliament that is pleased with the report and to actually engage on the matter. Yes, the matter is in the public domain, but now the proper structures in our country are seized to engage that report and allow that space. And I think that report will be made public on the 6th of December. So for now, my thoughts are Vuyo as citizens, and also as a member of the Women's League, would rather allow the legislature to take the process through. Thank you.
Now, it then raises, this question of leadership, I would dare say, because your former president, Thabo Mbeki, did say, or implore you, all of you, to really try and answer the question before, what just happened, to say, what if? What if? Do you not regret the fact that you or the rest of the ANC leadership didn't heed that call, because it may just create problems for you over the next few hours and days?
Let us not put a narrative there, Vuyo. The ANC has allowed the proper processes that are there in the country, which the Parliament of the Republic is the rightful place to really look into the report. Yes, you will find other former leaders and leaders of society having their own personal views, but I would not rather engage on views that are personal right now. Rather allow the process.
Let's talk then about the issue that Ukanye was raising, which was going to be the point of our conversation, because before the news broke, that, you as the Women's League are among the structures that have endorsed Cyril Ramaphosa for the position of ANC president. And I don't know if you heard Kanye saying, structures like yours should actually made it a point that they do support the women candidates.
Indeed, Vuyo, the Women's League has been very consistent and is very clear on the support of women. And bear in mind, the conference is the conference of the ANC. However, the Women's League went and made nominations. And it has nominated women, as the Women's League has been very vocal on the 50% of gender parity, and also seeing to it that the Women's League has nominated 3 women to lead the ANC at the official level. So and it agrees with you right now that yes, the Women's League is adhering to that call, and also the issue of 50-50 gender parity is not only the issue of the ANC League alone. The ANC at its national policy conference, overwhelmingly adhered to this policy position and welcomed it.
Why did you choose Cyril Ramaphosa and not Nkosazana Dlamini Zuma or Lindiwe Sisulu, for example?
Why would not? It is a matter of a principle, the issue of the president. The president of the ANC has been given second term, and it is also understanding, as I've said earlier, the process is a process of branches of the ANC, and of which, as Women's League, we are members of the ANC. And in that principle, we have made sure that we nominate 50% in the top 6 of the ANC, and we have done so.
Kanye, your thoughts from listening to Pelegwa?
Well, I think that Pelegwa raises a very interesting choice of words. She uses a matter of principles and also the process of nominating, which does indeed start at branch level. However, we also need to be conscious of the fact that even at branch levels, there are women league structures. So when we are talking about the Women's League, we're not just starting from the national executive, but the Women's League has a secretarial arm, and that's the arm that is responsible for coordinating all the branches. And if women, as she says, the Women's League has nominated 3 women, then those particular candidates have to be put forward from branch level up so that you are influencing from the ground up. I don't think that the Women's League, as just a national executive, will be able to do that. They have a responsibility to make sure that the women who go to the conference, the women who are voting at the conference, are voting for those candidates, and that's not happening. When she talks about matter of principle, then the women's agenda always has to come first when it comes to women's leagues. I feel like the Women's League is still under duress when it comes to the nomination of choices. I don't think they've reached a point where they can say we differ with the mother body and we can take it all the way to the top. Okay. I would love to see them become more decisive.
Let me thank both of you. We have run out of time, but thank you very much for kicking off this conversation. And if you have just missed it, according to Judge Ngobo and the rest of his panel's report, they have concluded that President Cyril Ramaphosa has a case to answer on Phala Phala. They are raising the enduring questions are the following: the source of the money stolen, why was the housebreaking and theft not reported, and why did the South African police request the Namibian police to handle the matter with discretion? Our sister program, The Globe, will be bringing you reactions from political parties and other players in a few minutes. So you want to stay with the SABC News for that. But from the Watchdog team, that's where we're going to leave it until tomorrow.